We are very excited to once again have our Legal Gold Rush series and have Colin Rule here today. Just to remind everyone, or if this is your first time, we strongly encourage questions on the chat function. If you want to ask a question, please type it out to Chris Bentley, who will be leading today's discussion, and he will ask as many of the questions as we have time for. We always have a hard stop at 2 p.m. because we know everyone is very busy. And also, we'll probably remind everyone at the end, but our next Legal Gold Rush will be July 14th, and we have Andrew Arruda from Ross Intelligence, so who I know is a good friend of Colin. So
oh yeah, Ross Intelligence, that's great.
Yeah. So we are very excited. But today we are very excited to have Colin. So I will stop talking and pass it on to Chris.
Well, thanks very much, Hirsch. Welcome, everybody. Delighted you've joined us. I am absolutely delighted to have Colin join us. A pioneer, a bit of a rebel, maybe, an access to justice leader, a person who has been out on the cutting edge of so many important initiatives to ensure that everybody has access to the rights and protections that they should have in their respective systems of justice. Who got something of a start as a Peace Corps volunteer in 1995. Colin, you were there in Eritrea for 2 years as a Peace Corps volunteer.
That's exactly right. Yeah, at the beginning, at 95, to me, it still seems like, well, that wasn't that long ago, was it? But then you do the math, you're like, okay, that was a while ago. Yeah, but yeah, it was a foundational experience, and part of my heart is still in Eritrea. Yeah, it was one of the best things I ever did with my life.
Why did you decide to go?
Well, you know, it's interesting. I was interested in peace from a very early age. Actually, I was a debater in high school. I did policy debate, traveled around the country and did these big debate tournaments. And that got me interested in peace. And for some reason, that really resonated with me, you know, the Peace Corps. Like, okay, hey, this is something I really want to do with my life. I actually had some adults when I was a kid who had done the Peace Corps and had talked about it when I was at a very impressionable age. And I said, you know what, that's something I want to do. So, and as I mentioned, the president of the small Quaker college that I went to had been a Peace Corps volunteer and had married someone from his service. So, and she was, you know, an active presence on the campus as well. So I just had in my mind, this is something that I wanted to do. Now, my wife, we met and got engaged and got married, and she had never thought about doing the Peace Corps. But I said, hey, wouldn't this be fun? And I talked her into it. So we applied as a couple, and we got stationed in Eritrea. She spoke fluent French, so we really thought we were a lock on West Africa, but we ended up in East Africa where nobody speaks French. And it was just a wonderful experience. Now, I went there thinking I'm going to do dispute resolution. I'm going to bring in some technology. No, we didn't do any of that. We were English teachers. We lived in a small village. There was a lot of other stuff that they need to worry about more than dispute resolution and technology, but still have very, very good friends who are Eritreans. We're very involved with the Eritrean community out here in Silicon Valley. So yeah, it was a wonderful time. So if anybody likes injera and a little Daro Zigni, you know, hit me up. We can go get some once the pandemic ends.
You were saying that it was a life-changing experience to spend time in the developing world, where so many people don't have. They've never made a telephone call.
Absolutely. Yeah, I mean, I think so much of what we do in dispute resolution is we sort of need to step into the shoes of our parties a little bit. And I think living in the rural Horn of Africa gave me a completely different perspective from the one that I had growing up in the United States. I mean, right now in the US, we're talking a lot about privilege. And I think there's an element of my friends in the United States, they said, oh, well, now you know what it's like to be poor because you lived in this poor, you know, African country. I said, no, now I know what it's like to be Bill Gates, you know, because we were getting paid $500 a year, which was like 3 times more than anyone else in the village where we lived. And they all knew that we were Americans. I mean, people would say to me, how much money do you make a year in the United States? And I was just fresh out of college. So I think I said, well, you can make like $25,000 a year. And their eyes would almost fall out of their heads, because that's more money you'd make in a lifetime in Dekamare, the village where I lived. So it really did set a frame, I think, for me in terms of the scope of human experience. And I really think that it's a valuable thing for people around the world. I mean, I know Canada has a strong culture of volunteer service, and we had a lot of European volunteers also in Eritrea with us, also people from India. But, I just think it really did change the way that I see the world, and it changed the kind of work that I wanted to do over the rest of my life as well.
So why dispute resolution? What got you into the field of dispute resolution? You've been a pioneer since the 90s and before.
Sure.
But why that?
Well, as I said before, I was really interested in peace. And the irony of the Peace Corps is I didn't really do much peace building at all. But peace was in the name. That was one of the things that drew me to it. But once I got to college, I started to study peace. It's kind of a diffuse concept. I mean, everybody talks about peace. There's religious texts that talk about peace. There's political science textbooks that talk about peace. There's peace as the absence of conflict, and then there's peace as sort of something that's a little bit more creative, more value creating. And when I first got introduced to dispute resolution, it seemed to me, oh, wow, this is the science of peacemaking. This is sort of using game theory. It's using economics. It's using psychology, to help people achieve the same objectives, which is conflict resolution, conflict management. So I just something went off in my head. I was at this small Quaker school, and I don't know how much people know about Quakers, but the American Friends Services Committee had a program where they were training people in dispute resolution, in mediation skills, because it's very much in line with Quaker theology. And I got a chance to take this training. It was just sort of a weekend introductory thing as a sophomore in college. And I went, click, this is it. This is what I want to do with the rest of my career. And every minute I've had in my career since then has been in the dispute resolution field. I love mediators. I love mediation. There's an art to it. There's a science to it. My background, it's ironic that I'm on the legal gold rush call because I'm not a lawyer. I've never taken contracts. I've never taken torts, but my whole career has been in dispute resolution. And that's just, I feel it's of a piece. Dispute resolution lives in the shadow of the law. So my wife says, don't you want to do something else at some point? I'm like, no, this is all I want to do until my last day of work is work in this field, because it's so exciting for me and satisfying.
Well, I know it seems ironic, but at the Legal Innovation Zone, we understand that if we're going to make progress in the law, we have to listen to a lot of voices that aren't lawyers.
Absolutely.
Including my co-founder, Hirsch Perlis. So we are
from all right, Hirsch, you and me, brothers, the non-JD brothers. Well, I will say, this is what I often say in Silicon Valley, is my lack of a legal degree, I think, is a feature, not a bug. Because my background was in public policy, so I really do think about these things from kind of that frame and sort of a coder's frame, which I think often helps me see things a little bit differently than maybe people that have had a legal education. Yeah.
I know you founded an ODR firm in the late 90s, and then you joined eBay.
That's right. That's right. Yeah, well, it's interesting too, because I'm a nerd. You can tell just by looking at me. I love technology. I've always been, but for me, technology was a hobby. I actually ran a bulletin board. This will date me even more so than doing Peace Corps in the mid-90s. I ran a bulletin board, which was a dial-up service pre-internet in the early 80s out of my bedroom in North Texas. So we had a 300 baud modem, and people could dial in and we'd post messages to each other. And I just loved technology all the way along, but I didn't see technology and dispute resolution as having any commonality. I would work in dispute resolution organizations and make the printers work, but we weren't really talking about online dispute resolution per se in the early 90s. But then people started to say, okay, well, the internet is coming up and there's disputes that are on the internet. How are people going to resolve those disputes? And I was general manager of a website called Mediate.com in the late 90s, and I said to my co-founders there, well, we got to come up with a way to do this. How are we going to resolve these disputes? There's going to be lots of them. So we started a company called Online Resolution, which was one of the first ODR service providers. And we built some software to help people resolve their disputes online. And I wrote a book called Online Dispute Resolution for Business. And then one day I got a call from eBay, a senior vice president at eBay. And he said, hey, I think we need to talk to you. Can we fly you out to California? Because I was living in Massachusetts at the time. I was like, wow, okay, sure. So they flew me out to California, and I met everybody on the team, and I gave them all my advice, and I gave them an invoice and said, okay, thanks. nice to meet you, take care. And I flew home. And then 2 weeks later, they called me again, said, we want you back out, come out again. Like, okay, so I'll take your money. So I flew out again, and then they started asking me interview questions. And I said, am I being interviewed? Like, I think I have to consent to that, don't I? And then they said, okay, we want you, and here's how much money we want to pay you. And I said, wow, I guess I work for eBay now. So I picked up my family and moved out to Silicon Valley, and that was a real education, because eBay at the time was the hot internet company, 2003. I mean, it was sort of the Facebook of its day. It was growing like crazy, and they were getting smart people coming in from all over the world. So we were wrestling with some of these problems for the first time that now all these websites have to wrestle with.
So what was the problem they presented you with when they said, yeah, we want to hire you in 2003?
Yeah, so the interesting thing about eBay was they knew they had disputes, but they didn't really have any system for dealing with them. Buyers and sellers would have disagreements. Somebody would buy something and they would show up and they weren't happy with it, or maybe they would buy something that wouldn't show up at all. So they created some tools. They were building a division within eBay called Trust and Safety. And they said that Trust and Safety had 3 legs to the stool. One was what they called FIT, fraud investigations, and that was getting the bad guys and throwing them off the site. The second one was what they called reputation, and that's the feedback system, where you can provide information about your transaction partners so that other people can have visibility into who are the good actors, who are the bad actors. And the last one was resolutions. How do we resolve cases efficiently between all of these buyers and sellers? Now, the only link when I first got to eBay to resolve a dispute was hidden. It was 6 or 7 clicks off the homepage, and they didn't get that many cases. They only had 30, 40,000 cases a year. And they kind of had an insurance model for dealing with them. But they had worked with an outside company called SquareTrade that was providing online dispute resolution services to them as a service, but they realized they wanted to bring it in-house. So they brought me in, and we built something called the Resolution Center, which was a console available to every user on eBay and eventually PayPal. And if they had any problems, they could just click one button and report it, and then we would track it all the way to resolution. So that was my job, was to design and launch the Resolution Center. And as soon as we launched it, the disputes went up, 5, 10x. And eBay was like, whoa, why did you create all these disputes? I said, I didn't create anything. These disputes were out there. We just weren't doing anything with them. And then over time, the Resolution Center took on more case volumes. And by the time I left in 2011, we were resolving 60 million disputes per year through the Resolution Center, which is more than the U.S. civil court system. So, it was huge. And I think it became an enormously validating point for online dispute resolution. The fact that you could create software, 50% of those 60 million we resolved amicably between the buyer and the seller. They just worked it out. And then 90% we resolved without a human from eBay having to touch the case. So we had a very highly automated system, and the technology did most of the work. And I think that was very, very interesting for other industries too that were dealing with high case volumes, because they're like, wow, how can we automatically resolve 90% of our cases as well? So that was what happened at eBay. So
just to set the stage maybe a little bit, using what you said about your eBay experience, there was a question that came in. What's the difference, or what are the differences between an online dispute resolution platform and an online mediation platform?
Well, mediation is one form of dispute resolution. Mediation is assisted negotiation, where a third party, neutral, comes in. They don't have any decision-making authority, but they can assist the two parties in going through a negotiation so that they can reach an agreement, mutual agreement. Because in a mediation, the parties have to agree, just like a negotiation. Now, when it's just a negotiation with no mediator, the parties own the process. And technology can assist a negotiation. It works a little bit differently than when a human assists a negotiation, but there is a bit of a fuzzy line between technology-assisted negotiation and online mediation. But usually we refer to mediation as where there's a human third party, and technology-assisted negotiation where there's only an algorithmic assistance to. And then, of course, you have evaluation and arbitration, which is where a third party comes in, listens to both sides, and renders a decision. So, and then there are some times where you have MEDARB, where the mediator becomes an arbitrator. So there are lots of different dispute resolution techniques. And when we brought in technology, we originally just started to replicate the face-to-face process online. But then we started to realize, well, wait a minute, there's things you can do with technology that you could never do face-to-face. And you get access to the disputes much earlier in their life cycle. So now we have problem diagnosis, and we have crowdsourced juries, and we have smart contracts. I mean, none of those things would have been possible back in the human-powered era where we didn't have technology inserted into the process. So we're seeing a lot of innovation in the ODR space around how technology can help people reach agreement. But online mediation is one very powerful component of ODR, but really there's a lot of other tools in the toolbox, as we say.
Was part of your success with what you developed at eBay that you set the parameters as to what kinds of disputes you would deal with, or it would deal with, what the possible outcomes were very early, so that the customer could see exactly what they were allowed to dispute. They knew what the potential outcomes were, and that helped to focus their decision-making process as you went along.
Absolutely, Chris. You really put your finger on one of the key components of why ODR is so successful and why it's spreading so
I might have read one of your articles.
Great. Well, then throw me more softballs, because I like hitting them out of the park. It makes me feel strong. No, but the point you make is absolutely right. I mean, remind me the focus that you wanted me to take in responding to the question. I mean, the lessons learned.
Just when you set up the eBay approach, and when you're setting up an ODR system, you want to be clear with the consumer what they're allowed to dispute, when they're allowed to dispute, and what the possible outcomes are.
Yeah, so if you think about face-to-face mediation, and I've done a lot of face-to-face mediations, usually the parties, they have a dispute that arises, and they negotiate with each other, and they can't reach an agreement. So they achieve a certain frustration as they hit impasse. And that frustration mounts to the point where they say, we need someone to help us with this. So let's go find a mediator. And then they have a mediator come and join. So you are really joining midstream in that dispute as a mediator. And you often have to say, okay, let's start from scratch. What happened? You know, tell me, just unassisted storytelling. Tell me from your perspective what's going on, other party. So you're trying to unwrap some of that frustration that's emerged. Now, online is very different, because you get access to disputes much earlier in their life cycle. So at eBay, for instance, we would have a buyer who paid for an item and the item didn't arrive, and they have sort of a mounting sense of unease. And they haven't even contacted their counterparty yet. But they would come to the resolution center and say, hey, you know, I'm kind of worried about this. I think I might have been defrauded. And then we would be able to say, okay, let's do an investigation. You know, when did you pay? What kind of item did you purchase? Where's the buyer located? Where's the seller located? How many disputes have arisen? And sometimes we could say, oh, they shipped the item. They gave us the tracking number. It's en route. It'll be at your house in 2 days. And the buyer would say, okay, great. Well, I'll wait 2 days. And then the item arrived. So the complainant never even notified the respondent that they had an issue. We could help them resolve it in advance. So one of the things we talk about in dispute resolution is the ZOPA, the zone of potential agreement. And when you can get involved in disputes much earlier, you can actually help to shape the conception that the parties have about what a reasonable resolution looks like. And that's often one of the challenges as a mediator. When you come in the middle of the dispute, the parties may be way far apart. I mean, one side said, well, I'll pay $50 to make this go away. And the other side says, well, I want $10,000 for emotional damages. And then to try and get that resolution into a zone of potential agreement is really hard work. Whereas online, if you can communicate with the parties that much earlier, you can actually help them say, okay, what kind of problem do you have? Like I said, we did hundreds of millions of disputes at eBay. So we had lists of problems. And we were almost never surprised because we'd seen everything twice. So people would go in and say, well, I have problem number 8. And we would say, okay, here's 5 common solutions to that problem. You know, which of these solutions would you be willing to accept? And you can customize those solutions. Well, I would take A and C and D. And for D, I want a partial refund and I want it to be $75. And we would say, okay, thank you so much. We're going to contact the counterparty. And then we would go to the counterparty and say, okay, look, this buyer bought this item from you. They say they have this problem. And here are the solutions they're willing to accept. Would you be willing to accept any of these solutions? And maybe they would say, yeah, I'll do solution A. They can return it to me and I'll give them a refund. Great. It was an automated resolution. And again, we're helping to structure that process. One of the things we discovered at eBay, and forgive me because I can go on and on about this, Chris, but one of the things we discovered at eBay is the tone of the first message in a dispute communication is highly correlated to whether or not the parties are going to be able to resolve it by mutual agreement. So one of the things we realized is the complainant, the buyer, if you give them an open text box, they're going to engage in threats and insults because they're trying to maximize their leverage in the negotiation. They may make accusations. They may say, I'm going to do this or I'm going to do that. So we realized we don't want to give the complainant the first message. So we would gather the information from them about the dispute through forms, through structured forms. And we would compose that first message for them and say, oh, is this an accurate description of your issue? And they would say, yes, that's right. But we would leave out all the threatening language. Now the respondent, the seller, has a strong incentive to make sure that buyer is happy. And we would coach that seller on how to communicate with their buyer. We would even write the first message from them, and then they could go in and customize it. But the tone of that message is very constructive. I'm so sorry we have this issue. Let's work together. Let's get it resolved. I'm committed to your satisfaction. So by using technology to rejigger the negotiation process, because we're essentially benevolently manipulating the negotiation to increase the likelihood it will resolve, by doing that change, we increase the resolutions by mutual agreement by 25%. So that's just an example of how early engagement can help you get more effective resolutions. And that was one of the lessons we learned after dealing with these millions and millions of disputes at eBay.
How interesting when you look at the court system as it has existed over the years, where you get the parties when they're in full litigation mode, they're ready to go at
Absolutely.
each other, as opposed to the theme of virtually every access to justice reform initiative for decades, which suggests inform people first, try and triage their issues, maybe resolve them in simple ways or connect them with people who can. Courts as a last resort.
Absolutely. And I think evaluative dispute resolution mechanisms have a place where the parties can't reach agreement, where it is me versus you, I need competent representation, let's go in, let's have it out, and then a third-party expert will render a decision. But that should be a tiny sliver of the overall volume of cases, because the vast majority of problems are not bad actors. The vast majority are misunderstandings. So if you have that frame and you can get early access to cases, you can resolve 80, 90, 95% of cases before you get to the human-powered evaluative mechanisms that the courts offer. And we even see that in the United States. 98% of civil cases resolve before they get to a trial anyway. Right. So, really what people are doing is they're using the litigation process. Actually, I did an interview the other day, and Tom Stepanowicz, who's a leading mind in arbitration, he told me about Mark Galanter's concept of litigation, where people are in a litigation process, but they use that as a stick to incentivize the other party in a negotiation. And really, litigation is the way we resolve the vast majority of our cases. Litigation ending in a hearing is a tiny percentage of cases, and that's as it should be. Yeah.
So if we placed more emphasis on the early stage, informing parties about what their options really are, giving them different routes to resolve, we'd have a lot fewer unhappy litigants going through the court process.
Absolutely. And let me tell you one other story about eBay, because it's not only that you resolve disputes at the earliest inkling where the complainant feels like they have a concern. You can also go earlier than that to change the process to eliminate the source of many of these disputes. Right. So what we saw when we had hundreds of millions of disputes, we had a lot of disputes around returns, because people were like, well, who pays return shipping? Or how long is my return window? Or all of these questions. So we realized we need to stop this. So we went actually earlier than the purchase to the team that built what we call the sell your item flow, which is where the seller goes and they list their item. And we said, we want to add some fields to that form about returns. So sellers would be explicit. This is an as is no returns item, or you have a 2-week return window, or buyer always pays return shipping. So when the buyer was buying the item, we had a box there that said, this is the return policy. And then when an issue arose, the buyer said, well, I saw that. When I bought the item, I knew that there were no returns allowed, so I'm not even going to bother to pursue it. And again, we saw a reduction in the disputes around returns. We're talking about millions of disputes that never occurred because we went upstream and we removed the miscommunication that was generating the disputes in the first place. So many of us in the dispute resolution field and the court area, the litigation, judicial sector, we're reactive. We don't go earlier to say, how can we change the process to make sure these disputes don't arise? But we know exactly how to prevent those disputes. It's just people don't talk to us until they have a dispute. So if you take this holistic perspective, then you can remove the irritant from inception. And the best way to resolve a dispute is to prevent a dispute. Absolutely.
Well, you knew that at eBay because you mined the data. You listened to what consumers were saying. Courts historically are, and those who manage the courts, have historically had a challenge in doing that because they haven't necessarily put the data together, understood the sources of the irritants, and worked with government to change the sources. But I want to talk about when you left eBay. You left
Sure.
because you licensed this platform that you developed,
That's right.
the Mode RIA platform, and you launched Mode RIA.
That's right. In 2011, I spun out a company from eBay. We took some of the technology we built inside eBay, essentially this resolution center platform, and we started to say, okay, where else could we apply this? So we ended up building resolution centers all over the place for lots and lots of different places. And of course, leaving eBay, we thought, well, e-commerce is a great space for us. So let's go sell to Amazon, let's go sell to buy.com, let's go sell to Alibaba. But then we started to realize, okay, wait a minute, all of these collaborative economy companies, Airbnb or Upwork or TaskRabbit or Lyft, they all have disputes because you're creating a marketplace. And it may not be buyer and seller, it may be host and guest, or it may be rider and driver. But there are disputes that need to be resolved. But then we started to get contacts from people offline who said, hey, we'd like a resolution center for our cases. We're not a website. I mean, we worked with Consumer Protection British Columbia to do nail salon disputes and, cable modem disputes. We worked with the Property Appeals Assessment Board in British Columbia to do tax disputes where people felt like the valuation of their house was too high. We started to look at insurance, healthcare. I mean, once you put the dispute glasses on, there are disputes everywhere. I mean, it's just, it's an infinite realm of possibilities. So we started to build resolution centers like we had on eBay for all of these other dispute volumes.
So you effectively had an approach that would work for multiple disputes. You take this to different organizations, private,
right,
for the most part private organizations. You're able to replicate this, and all of these disputes have common features. There are lots of them. They would overwhelm the courts if they ever went to court, and they aren't in and of each one. They're not for enough money that would ever justify going to court. And the reputation of the organization was at risk if the disputes weren't resolved.
Well, it is interesting. When I started Online Resolution, the first company we talked about, I was targeting business-to-business disputes, say $100,000, $250,000 in value. I thought that was kind of my sweet spot. But I started to get pushback from the bar associations. I started to get unauthorized practice of law letters saying, hey, back off, because these are disputes where lawyers could make money. There's some billable hours in these cases. And I was scared. I didn't want to get sued. So what happened was I went down market, exactly as you say, high volume, low value cases. On eBay, the average value of a dispute is usually $75. So there's no billable hours in that, and once I started doing those disputes, I didn't get any letters from the bar associations. They were not worried about me, and again, if you add up all the cases, wow, we're talking about hundreds and hundreds of millions of dollars, but they weren't structured in a way that the legal system could really do anything with them. So I think it's a question also, I think that there's a lot of utility for technology in these higher dollar value cases, but the thing is, that's the bread and butter of the legal industry. So a lot of the rules, kind of these anti-competitive rules, have been set up to prevent outside interlopers like me from coming in and resolving those cases. But now what we're seeing is, I think there's some cracks in the dam cracks in the foundation, the walls outside the fortress, and people are saying, hey, wait a minute, technology has the potential to really expand access to justice, and some of these rules may be preventing technology from delivering as much value as it possibly could. So we see bar associations, we see chief justices, particularly in the United States, but around the world more broadly, more open to these kinds of innovations because they realize these changes need to happen.
So I'm going to get to another question about small claims court in just 2 seconds, but I want to follow up on the regulatory structures and the monopoly granted to lawyers throughout the United States and in Canadian provinces to deliver legal services, and the access to justice crisis, which in civil and family matters means most people and most cases. Are the regulatory schemes that exist to protect the public by giving lawyers a monopoly, first of all, are they helping the public, including businesses? But secondly, are they even helping lawyers?
Right. Well, I often say, who's the biggest victim of the billable hour? it's lawyers. That's a tough way to live your life, is billing out your time in, 5 or 8 minute increments. I mean, it's a tough gig. And I think in the States, there's been studies that show that lawyers have some of the worst mental health of, many of the top paying professions in the country. But again, people don't trust lawyers. I mean, it's almost, all these lawyer jokes out there. I think it's not that lawyers are doing bad work or that they're not working in the interest of their clients. I think the design of the justice system is intended to provide equal justice to all. Just the reality of how it's working in practice, unfortunately, not operating that way. We have a crisis of self-represented litigants in the United States, people who are trying to self-navigate the civil justice system, and they get terrible outcomes, and they create enormous churn within the court system because they don't know what they're supposed to do. They don't know what documents, so they come to the courthouse and they're walking around saying, what should I do? They go to the legal library and say, can you tell me what I should do next? And the legal librarians are worried because they don't want to get in trouble for providing legal advice too. We have rules in the United States. If I'm a California lawyer and I provide legal advice to someone in Oregon, I can be disbarred. And the internet doesn't care about California versus Oregon, And I mean, in California, each county is kind of its own legal jurisdiction. It has its own forms. It has its own processes. So it's incredibly balkanized. It's all chopped up in terms of how these processes operate. And what's amazing to me is now that I'm doing landlord-tenant cases, I'm doing debt cases, I'm doing small claims, I'm doing family cases. Now, my good friend Darren is on from CSD, who's innovated this in Canada. I mean, been leading this effort. And I think he'll tell you too, it's not like family disputes are different in Ontario than they are in BC or different than California and Oregon. I mean, it's the legal process that's so ornate. I think that there's this kind of, legal priesthood that has this language that it's so complex. You need a lawyer. You need someone who's trained, who's gone through school, has taken all these exams to help you navigate it. But when you can't afford someone like that, the process is really a morass. And that's why I think this whole field of alternative dispute resolution has emerged to help people try and find resolutions outside of having to go through that very ornate, complex process. I've had people at Bar Association meetings where I've presented, they think that access to justice is synonymous with access to lawyers.
Right.
And that may be true in a process that's this complicated, but I don't think it has to be this complicated. I think we can be creative and we can rethink it and come up with a user-centered process where, working with technology, they can achieve, resolutions in 90+% of cases. And I think I think technology represents the biggest opportunity to expand access to justice in the last century, but we got to get some of these antiquated rules out of the way so we can truly leverage it.
Well, now let me get to the small claims court question, especially since you acknowledged Darren, and hi, Darren. So the question is, the Ontario Small Claims Court person has been involved, we'll just say, for 25 years. Instead of streamlining, they're getting worse. We're having multiple settlement conferences. Trials of more than 2 days are not unknown. Even if you get a judgment, difficult to collect. How do we start to fix it with the COVID backlog? They may have an extra 4 months of delay on these cases, which are designed to be a process for the smaller value claims. Take it away, technology.
And small claims court, it was supposed to be an expedited process, right, to keep you out of the main court. But now, I mean, what we're seeing, again, these processes, they become more procedurally complex. And I mean, again, I've done a lot of small claims mediations. I know a lot of lawyers who've been involved with small claims. I cannot envision a circumstance where I would file a small claims case, knowing what I know about that process. And again, lawyers are the ones who know the failures of the system better than anyone else. So it is not a system that's optimized for participant satisfaction. Now, that said, there are a lot of small claims courts, people that work very hard and they provide very good process and they provide as much support as they can. And I think small claims, again, there was a guy in the States, a guy named Frank Sander, who's a professor at Harvard Law School, and he came up with this notion of the multi-door courthouse, which is, instead of just people ushered into the courthouse and they go in front of a judge, there's a table out front. And somebody at the table says, okay, what kind of dispute do you have? Well, I have a family dispute. Okay, you go through door number 2. And in there's a special process just for family disputes. Next case, what kind of dispute do you have? Well, I have an intellectual property dispute. Okay, you're door number 8. And this was a radical idea when he came up with this in the 70s. But Frank was really one of the fathers of ADR. And one of the things he talked about, in addition to the multi-door courthouse, is what we call fitting the forum to the fuss and building appropriate resolution channels for each dispute type. And I think small claims courts and landlord-tenant courts and family courts are an example of that. Let's build a process that better meets the needs of these particular kinds of disputes. But again, Canada is way ahead. I think I said this to you before, Chris. I love doing dispute resolution in Canada because in Canada, you know, in the States, we talk about life, liberty, and the pursuit of happiness, which is all me, me, me. It's all about my life, my liberty, my pursuit of happiness. In Canada, it's about peace, order, and good government. It's about us, all together. I feel like the culture is much more predisposed. I mean, I understand maybe I have a rosy view from south of the border, but I think there's just an element of we need to work together to provide as much justice as we can to as many cases as possible. And I think thinking expansively about the use of these tools, it lets us sort of redesign the justice system. Like, let's build a new justice system that leverages all this power that can really open the doors to people. And I think that requires a rethinking of the lawyer-centered model.
So I know that's what you were doing when you developed and spun off the Mode RIA platform. It was acquired by Tyler Technologies. You've been working with governments throughout North America. I know you've done work in BC with My Laws.
That's right.
BC. And Darren, of course, along with Shannon, two of the founders and the creators of the Civil Resolution Tribunal in BC.
Absolutely.
You can apply the principles that you developed at eBay, and I know it's radical saying this, but you can apply those principles to a small claims court scenario or public dispute resolution scenario without harming people's justice interests, can you not?
Absolutely. And, you know, I think, again, Shannon and Darren and the MOJ and BC have been on the leading edge of thinking, how can we take these tools and techniques and re-envision the justice process? I mean, again, working at Tyler has been very interesting because I've been working with lots of courts, and they're trying to modernize their services because what they fear, a lot of these court administrators and court clerks, they fear that they're getting sucked into what they call the spiral of irrelevance, which is where they don't offer online services. And increasingly, citizens, particularly millennials and Gen Zers, they're like, I'm not going to go down, you know, between 9 and 5 to some building in downtown and stand in line and wait to, you know, submit my form at a window. They're going to go build an app, you know, because everything in the lives of young people in particular is online. So if the courts are not online, then it may be that they just become increasingly marginal. You know, I think, again, the courts work really well if you have a lot of money and you have competent counsel. But if you've got a small level, you know, civil complaint or a landlord-tenant dispute, you know, it's not really a good fit with a lot of those cases. So I think there's a lot of alternatives that are emerging. And what I give the BC credit for doing is sort of seeing around the corner and saying, you know, we're going to innovate here. We're going to build an all online court, and we're going to take these caseloads back from the provincial courts. And what you see is the CRT's success metrics are so incredible. Every month they release them, and it's 98, 99, you know, % satisfaction. And citizens are saying loud and clear, we want to do this online. We want to get these resolutions online. The systems that we built in the States, 85% of the resolutions happen outside the hours when the court's open for business. So again, the citizens are saying loud and clear, we want, just like every other area of our lives, we want the courts to be able to operate online. But again, as a dispute resolution guy, I want to resolve these cases before they even get to the courts. I think, you know, there's a lot of process and stuff that happens inside the courts. It's not necessary in the vast majority of these cases. And I think if you look at the overall volume of disputes where resolutions are negotiated in wider society, I think less than 0.01% of them ever end up in the court. You know, we all have disputes every day that we just work out in our lives. So that's what I'm saying. I want to move upstream to prevent these disputes and resolve them early, as opposed to waiting downstream and being reactive in the courts, because that's where there's a lot of cost and a lot of procedural. The courts are necessary as a backstop, but they certainly shouldn't be the first place to get resolution when an issue arises.
So before I appoint you the Minister of Justice to do that, and I'm going to get
without
to that.
a law degree. Yeah.
Well, you know, the power. You know, you don't have to have a law degree to be a Minister of Justice. We had a very good Attorney General. We've had Attorneys General in Ontario who have not had a law degree. So it's not.
Is that right?
Yeah.
Good for Ontario. Yeah.
Yeah. So, and as I said before, maybe it's time for some fresh thinking. You know, what is it? You do the same stuff in the same way, you get the same result.
Same result. Yeah.
So let's think about let's think about applying technology to the low-value court system today, the low-value dispute system today. Why,
Sure.
why don't we have more? I know the bar has traditionally resisted. Many lawyers even resist using online dispute resolution platforms for various reasons. But leave the bar aside. How do you tell consumers or get consumers to use it in the public area more frequently than they might be?
Well, it's a great question. At eBay, we did user experience testing. So we brought people off the street, to come in. We gave them some pizza and $100 and said, hey, we'd like to ask you some questions. So we were all behind a one-way mirror, and they were in a room, and, they would go through our little mocked up websites and give us feedback. One of the things we realized very quickly from doing this user experience research is nobody knows what mediation is. 90% of people thought it was meditation. Why don't you use meditation to resolve your dispute? And like, why would I meditate? People didn't know the difference between mediation and arbitration. They didn't understand really negotiation. Like, the language that we use to describe what we do is not the way that our users, that our customers actually think about the situations that they're involved in. So even the word dispute, even the word case is profoundly alienating to a lot of these participants, because they're like, a case makes them think, oh my gosh, this is going to be like a legal thing. I'm going to have to track it and submit evidence and blah, blah, blah. A dispute sort of implies a certain level of, moral responsibility for the disagreement. And a lot of people, they don't want to be seen as filing a dispute. So what we realized at eBay was we turned it into sort of a framing of problems and solutions. Oh, you have a problem. Well, let's find a solution to your problem. We found that language was much more palatable to the average person. So I think one of the challenges we have in trying to get people to use these solutions is we're not customer centric enough in terms of delivering things to them in the way that they think of their own situation. If you say, click here to file a dispute, you're already alienating 50% of people, because they don't want to be the kind of people that click a button that says file a dispute. But if you have a button that says report a problem, oh, sure, you'll get 100% of the people. I work with a lot of public agencies. Like I said, I did a lot of tax appeals. And I would go to these assessors and I would say, how many disputes do you have? And they were elected officials. They would say, oh, we don't have any disputes. We don't have disputes with our citizens. And I said, okay, well, how many appeals do you have? They said, oh, we have tens of thousands of appeals. I'm like, okay, all right, fine. From my perspective, let's call it an appeal. But I think we have to really be user-centric in the way that we design these tools. I think the use of technology is part of that, because we're hearing loud and clear from users that they do want to be able to file these disputes online and get resolutions. At eBay, we just made it part of the process. Like, oh, you got a problem? Let us know. And then they would be in a dispute resolution process, and they would go through negotiation, mediation, evaluation. But we never used any of those words. Our average time to resolution on eBay was about 3.5 days. And what we found is if a resolution took longer than 12 days, people were more frustrated than if they'd never filed a dispute in the first place, or if they filed a dispute on day one and they'd lost on day one. People would rather lose their dispute quickly than have a long, drawn-out process. Now, how many cases are resolved in the courts in less than 12 days? I would guess zero. So the expectations that parties have for how these processes should work are completely out of sync with the actuality of the way the process works. And we do have a lot of litigation romanticism. We have all these movies and TV shows with lawyers, and you have 3-day trials. I mean, when I was doing small claims mediations, people would bring in their file folder and they would say, well, I'm going to call some witnesses. And when the judge sees all these photos, I'm like, let me walk you through this. The judge is not going to look at anything in your folder. You're not going to call any witnesses. This is not like Law and Order. This is not like LA Law and Suits and Boston Legal. They're going to ask you 3 questions. You're not even going to get a decision today. They're going to mail it to you. And people would say, wait a minute, what? When confronted with the reality of the justice system, as opposed to the litigation romanticism, people said, I wouldn't do this again. I'm going to find another way to resolve my issues. So there are innovative organizations. I think about the Condo Board in Ontario. They're doing some really creative stuff, because there's a lot of strata disputes. And if you build an online expedited process, people will use that and they'll work out those issues. Nobody wants to go to court over a barking dog. It's going to take months, and it's just going to generate more frustration. And you have to be in the elevator with these people, So like, is that really the right way to do it, to lawyer up and just, bash your heads against each other? Or is it better to have a resolution process where you can sit down, with a mediator, talk through possibilities, and come up with a reasonable solution that works for both sides. So I think that it's a cultural change too.
So technology is at the heart of what you've been able to do. And from the beginning, you've used artificial intelligence. And of course, the capability of that has mushroomed and continues to grow exponentially.
Sure.
Should we be happy that AI is being used, concerned, or a combination?
I think a combination is the right answer, because there's still a lot of open questions around how AI and machine learning is going to be used. You know, I will say there's also a lot of misunderstandings about what AI and what AI isn't. I mean, again, this could be, you need to bring Darren back. He's done amazing things with Watson and IBM, thinking through all of that. And emotional, relationship-based disputes like family cases, there's a lot more potential value that can come from the use of some of these tools. But, you know, like one of the things we do in small claims disputes at Mode RIA when we work with the courts is we use algorithmic tools. Now, that's not AI. Obviously, AI is where you have a giant set of data and you have an algorithm go through and learn, essentially glean lessons from that data that can be applied to future cases. In a simple algorithmic example would be, if you have a small claims case and it's monetary, you say to the complainant, well, how much money do you need to resolve this case to, work it out for you? And they say, well, $1,000. And then we say, okay, confidentially, what's the lowest amount you'd be willing to accept to close this case? And we're not going to share this with the other side, but if you received more than this amount, you'd be willing to say yes. And, well, I'd close it for $800. So then you contact the respondent and you say, okay, this person has this issue with you. Here's their evidence, and they want $1,000. Are you willing to pay them $1,000? No, I'm not. Well, how much would you be willing to pay them? I'd pay them $900. Bang, you got a resolution, because it's north of the confidential amount that was requested by. Now that's not AI. That's about as simple. I mean, a third grader could do the math that undergirds that algorithmic solution. And that's a very simple example. There's other ways you can use game theory and math-based calculators and things to resolve disputes. You don't have to go full AI, but people do trust algorithmic resolution processes like that, because they can change the incentives in a negotiation and they can urge people to be reasonable, and you can get faster resolutions. Now, AI, if we start to get giant data sets, which we're now getting because computers are enabling us to capture all this information in structured form and train algorithms on it, we may get one day to the point where we trust an algorithm to decide our family disputes. And it's using AI to look at all of these past cases. Just like we're going to trust computers to drive all of our cars in 20 years. And it's going to seem incredibly barbaric that, we all drove to work and somebody could sneeze and, take out 3 other cars. Computers are going to run everything, and we're just going to trust it. And maybe in the future, we'll be comfortable with computers are going to be so smart and AI is going to be so capable. We'll say, all right, computer, what's a fair resolution to our divorce? Here it is. But I think it's going to take a while for us to get there. And I think a lot of these presumptions about AI taking over the justice system, I think they're a little premature. I think we have a long way to go before we get to that point. I think AIs are going to have to work in parallel with us for a long time before they get smart enough to actually take over some of those responsibilities.
Well, speaking of taking over, I've now used the power of a co-founder and a co-host to appoint you Minister of Justice for an amalgam of national and state jurisdictions in the States, or national and provincial jurisdictions here and territorial jurisdictions here in Canada. So what are the 3 things you do to, what are the 3 priorities you have for improving the justice system? And you don't have to worry about judges getting in the way, lawyers getting in the way, governments getting in the way. You've got the right to do this. So 3 priority areas and the 3 things that you would do.
Well, I would tell you, I've been doing a project with the Pew Charitable Trust, which is a big foundation down here in the National Center for State Courts. And we've been talking about how can you use technology to expand access to justice. And I think the blueprint we've come up with is great. First thing I would build is litigant portals, AI-powered conversational interface litigant portals for every jurisdiction across the United States that could be on every mobile device. You could put them in, Alexa-based, Amazon Echoes in libraries. People could come up and talk to them. And I would remove the restrictions around delivering legal services, particularly for low dollar value civil cases, through channels like that. So people don't have to worry about the unauthorized practice of law letters. That would be my number 1 move.
What is the litigant portal? What's the litigant portal do?
It really provides an intake, diagnosis, and triage process for people who have a problem and need to find a solution. So it can educate them about what their options are. It can tell them what the steps are. It can point them in the right direction. It can help set their ZOPA and what we call the BATNA, the understand your alternatives to getting a negotiated agreement. So I think litigant portals that becomes the massive intake point where we can throw the doors to the justice system open using technology. And then the next thing, obviously, is I would significantly expand the use of online dispute resolution to handle these cases. So just like the CRT, people don't have to have a lawyer. They don't have to show up in person. They can go through an online, simple, kind of TurboTax type process to walk through getting a resolution that works for them, and then they can memorialize it. I would also go all the way through to having your hearings online and having the outcomes from those online processes be as enforceable to any process you go through face-to-face. And the last thing, I mean, as we leverage technology, maximally leverage technology to generate efficiencies on the civil side, it's going to generate a lot of savings, save time, save money, save resources. I take all of those resources and I would put them into the criminal side. Because the fact is, the criminal side right now, that's life and death for people, and we are significantly underinvesting in that system. We don't have adequate access to counsel. We have huge disparities for people of color in the criminal justice system. So I think we need a lot more funding in the criminal side. So I don't want to take $1 out of the justice system. I just want to leverage all of the efficiencies we can get from technology on the civil side, and I want to put the savings in the criminal side. So if I had a magic wand and I was in charge of everything, that would be probably my strategic blueprint.
So fantastic. If I'm a young lawyer with most of my career in front of me,
sure.
I notice I said if.
You're a spring chicken, Chris.
And you've designed spring something, and you've designed this this litigant portal. You've got the ODR system. Where do I find my career? Totally.
Well, let me tell you something. Okay, so I'll get a little George Jetson on you here and get a little futurist. The good news is we know what's coming for the law because it's already happened in other fields. If you look at what's happened in medicine, if you look at what's happened in finance, if you look at what's happened in entertainment, those fields have already been completely transformed by technology. That's what's coming for the law. My grandfather always used to say to me, he's an old crusty Texas guy, he said, Colin, don't build your business where the highway is, build your business where the highway is going. And I'll tell you, there are a lot of lawyers that they look at this and they have no idea where it's going. If you're one of the lawyers who sees where it's going, you have an opportunity to get ahead of it. And there's going to be enormous opportunities in the justice system. You know, the justice industry is a $450 billion industry around the world. And now we're talking about, let's get technology in here to help us do it better. If you think about finance, it used to be that there were people on the floor of the stock exchanges with a piece of paper, and they were shouting out orders like, I want to buy 500 IBM. Who wants to sell me that? Now there's no one on the floor of the stock exchanges. That's all computers, and they're doing this in milliseconds. The future of the justice system is going to be we program the computers and the computers resolve the cases. So if you're a plaintiff's attorney or you're a defense attorney, you're going to be utilizing technology to negotiate and resolve these cases at scale, much more efficiently, much more effectively. And that may be blockchain and smart contracts. That's one potential future. You see crowdsourced solutions like algorithmic justice, where instead of backing these outcomes, these cases, you know, the enforcement with the coercive power of the state, we instead use math because code becomes the law. So we can automatically enforce these outcomes. So it's not the circumstance where you go to small claims and you get a decision and then you have to pay more money to just get your decision enforced. You know, like what's the point of a decision that's not going to be enforced? It's not even worth the paper that it's written on. So we can build new systems. We're going to design a whole new justice system, and it's going to work the way the internet works. It's going to be all online. It's going to leverage machine learning. It's going to leverage these bots. It's going to be cross-border, and it's going to be far more efficient. And if you can see some of these things coming, go build a software program for labor management. Go build a software program for elder disputes. Go build a software program for construction cases. Somebody has to do the innovation. Each one of these caseloads is going to require its own software and its own user base. So this is an opportunity. I mean, you talk about the legal gold rush. That's what I think this means. Eventually, the dam is going to crack, and there's going to be there will be a billionaire in legal tech. I guarantee you there will be a billionaire. The problem is they may be in third grade right now. We just don't know how long it's going to take. But by getting ahead of it and seeing what's coming and getting smart about these things and building the tools, then when the dam breaks, you can ride the wave. That's what I think. So it's not gold ingots in the river anymore. It's cases. But if we know what's coming and we have our eye on that and we can get ahead of it, then we can benefit from it. The people that say, no, I'm just going to go get a job at a white shoe law firm and I'm going to bill for my time in 5 minutes and just kind of, ride it out and do things the way it's always, that's going to be a shrinking pie over time. So that's my advice.
Colin, I can't figure out a question that will possibly allow you to top that answer. So I'm going to take this opportunity to say, what a fantastic hour this has been. I suspect there'll be, 60 or 70 jurisdictions in North America alone that want you as the next Minister of Justice. Not necessarily the political leaders or the legal leaders, but the people will want you. And your advice on on reforming the system, just absolutely fantastic. And I really appreciate your advice for those lawyers who have more of their future, because they've been listening to many voices that say any change is bad for your future. And it's great to hear you say the opposite. I really appreciate your time, and thank you so much. And I'm going to flip you over to Hirsch for the final words.
Thank you so much, Chris. Thank you for the great questions. Wonderful conversation.
Thanks, Chris. And yeah, I'm just want to thank Colin again. That was fantastic. And I mean, you hit the nail right on the head with that. There's going to be a billionaire lawyer, considering you are speaking at the legal gold rush, the unmet $1 trillion market. So yes, Chris and I, and certainly you, believe that there will probably be more than one billionaire in the legal market, and hopefully it isn't a grade 3er. Hopefully maybe it's someone on this call. So yeah, thank you again, Colin. Thank you.
Please give me some early shares. That's all I ask.
Yeah. And thank you everyone for joining us again. We will be back, as I mentioned, July 14th with Andrea Ruda from Ross Intelligence. So please enjoy yourself and stay safe, stay healthy, and have a great day.